Добрый день, уважаемые коллеги.
Good afternoon, dear colleagues. I would like to start this roundtable. And first I'd like to set the scene. Today we're going to talk about new cyber law agenda. Actually, it's called differently in Russian. It's called New Digital Things in Russian, and it's not lost in translation. It was our conscientious choice, because if we talk about the American and European experience of dealing with digital law, the things that we're going to discuss already well known to them, but for us it's something completely new. So the things that we're going to talk about, we're going to discuss their materiality. So first, the topic that we are going to tackle is big data. And the first aspect that we'd like to touch upon is security of private life, protecting private life, because this doctrine holds true for Europe. We'll see whether it's true for Russia as well. And we're also going to talk about the cyber security. Some of the issues that we're going to talk about are trans-border and cross-border transmission of big data, because today we're witnessing a new economic trend. The government is there to protect such big data, and they need to create conditions for the big data turnover. And another interesting aspect that I'd like to touch upon today are various trends that we see today, the trends of nationalization, of the internet itself, and some of the aspects of the internet. So I'd like to talk about this topic not just in the framework of the legal practice that they're planning to introduce in Russia, but we will also approach this problem from the US perspective and the European perspective. If there are any questions, you are more than welcome to ask them during the discussion itself. I do not believe that we must stick to a very rigid agenda in here, but again, in the end, there would also be left some time for our Q&A session. I will not... Well, without any further ado, I'd like to give the floor to Dmitry here, who will again set the scene, who will talk about the main problem, so basically about the challenges as we see them in the legal framework. Please, Dmitry. I'd like to thank Anna for giving me the floor, for the opportunity to speak. This is a grand event in a grand building, and it is fully in line with the scale and scope of the problems that we are discussing today. Anna has proposed to title the session as the Things of the New Age. And I wholeheartedly second this approach. Today we're talking about some new entities. And our objective is to identify their place in the system of law. When we talk about the things, it means that we have to talk about the civil law, private law, but we suggest to approach these entities from the property law. And here, some clarity of the academic paradigm is we are taking risks. We're risking to lose some of the developments that's been here for thousands and thousands of years of the legal science. And we actually start thinking, we may start thinking about these things, of these matters, in a language of journalism. in a language of a common citizen, and in the language of a politician. When we say today that property is entitled by Constitution, is a constitutional right, by this we open up the doors to wild terminology and descriptions. And we risk to follow in the footsteps of the Strasbourg court, which doesn't have anything about the private law apart from one article. And the whole system of private law that it tries to build is a thing entirely that's done by their own. Or we need to express this in a stronger way, is an amateurism. Yeah. These are imaginaries. These are the things that depend on the imagination. The people act as if they live in the 13th century, as if they don't know anything. And they believe that they may get to know something without actually using the 1,000-year tradition. The question is extremely serious in here. When we talk about property in categories of the constitutional law, in categories of the human rights, and this is Article 1 of the protocol, and that's where it all ends, we are left out in the desert, and vice versa. If we're trying to approach property from an economic standpoint, or from a political and economical standpoint, then we talk about social issues rather than the legal issues. And still, since we're experts, we need to put some efforts and to become more disciplined in order to obtain new knowledge in the framework of the existing system. Let me tell you about the existing system a few words, and what kind of opportunities we have in here. And there are opportunities. And this will be a much wider vision over the things and matters that are not matters as such, but they can still be permissible. This category of bodily things, bodily matter, finds its way into different coda verily, this famous paragraph number 90 of the German BGB, yes, Civil Code, states that matters in legal terms can only be bodily things or tangible things. And for a German lawyer, intellectual property is a metaphor. And legally, it's not a technical definition. However, sometimes in books on property law, we can find a saying that, in accordance with the constitutional law, this is the property. So, tangible things category is opposed with a non-tangible things category. And this non-tangible things category has been given compromised in the feudalism times. Has been discredited in the feudalism times. The thing is that in feudalism there are no things whatsoever, or no matters, and there are no people. There are roles that subjectively correspond to things, to objects, which this or that feudal can actually manage. But the feudal himself does not belong to himself or herself. They belong to their own estates. They belong to a feud, the function of which they represent. And in this case, the existence of bodily or tangible things in the bourgeois epoch was also the existence of physical people. On one pole we have a tangible thing, on the other pole we have natural, real, physical people. And his freedom is this human freedom. And this freedom is implemented through the free ownership of things. This consolidation, this concentration on both poles, this approximation to the reality, is in fact the possibility of conquering the right of the bourgeois epoch. Now, what about the category of intangible things? It belongs to the Roman law. When the problem of finding a man and the problem of finding a thing was not even existent, or was not even raised, or was not that acute, or it was actually resolved, yeah. It was not so pressing, because at that time there was no feudalism. And there was no opposition, there was no other point of view against which you have to propose such terms as tangible things. The Roman epoch is very similar to ours in this regard, because back then they were already standing on a very solid ground, and they could develop the law focusing on the market demands and needs, and not on the social problems that the law can probably solve, presumably can solve, yes. So this is the story. Today, the things, the wealth, the matter is not always tangible. What's interesting, they are always tangible, but they might not have the body. They cannot be embodied in something, and many things you cannot touch. Given that, in terms of definition, these things are consolidated, and you can really consider them things because they're finite, they're definite, and they can be presented as the things owned. Owning such things can work, or can contribute, will contribute, the development and strengthening of a person's autonomy. And it seems that a man is much more wealthy than the world of bodily things can offer. And the legal world can describe not just the bodily things or tangible things and ownership of them, but basically it can describe everything that the person can own, it can have, everything that can participate in a turnover, everything that can be sold at the market can serve as a matter that you can own, a matter of ownership. Dmitry, please try not to deviate from the topic and go deep into the theory. Just a couple of more words. Well, in such an approach, we can better understand the term ownership and term belonging and titularity. When Gaius, the Roman lawyer, proposes the theory, or he systematically presents it, this theory of intangible and not embodied things, he says there are things that have the body and things that are not having the body. And he proposes this list of 3 intangible things. He says this is inheritance first. And although inheritance might include very often tangible things, the right of inheritance is intangible. Second, servitudes and usufructs. And although the fruits that we can obtain by using this right are tangible, the right of usufruct is intangible. And the third thing, liabilities. Very often, liabilities may explain some tangible things, but the liability itself is intangible. 3 minutes. Is it okay? You have 3 minutes more. I will give you back the floor. I'm going to finish. Just a little more. Have a look. It's very interesting. We see a picture like this in front of us. There's university and universality. Jus universum, inheritance. We see this right userhood and titleship, and we have liabilities. This is the list of subjective civil rights. What kind of right are we missing in here? We're missing property. So it so happens that Gaius either connects property to a bodily thing, and this is a pandectium vision that exists in all the books of the 19th century or the 20th century, or he just sorts up the objects. But then titleship will end up in the same row as titularity. Titularity is a notion that connects the object with the subject. It's not the right by itself. But property is the right. There's only one approach remaining. To present this system is to accept the possibility of property on usufruct, property on inheritance, and on liability. With such an approach, the idea of intangible things opens up a way to new interpretations and gives us a possibility to use property terms for talking about any property rights. Thank you, this is it. Thank you very much. This, I think, was a very important presentation, a very important speech, because it provides us with a backbone. It provides us with something to jump from to describe the things that we face. Because in this case, law serves as an institute that services or that protects the turnover of such new things or new matter. And in this case, the law serves the rights of the government and protects the rights of a person. But the main idea is to protect the turnover, the circulation of such kind of new things. And recently I was reading a leaflet of a company that was going for an IPO, initial public offering. And this company was a manufacturing company using 3D printing technologies. This is a new matter, this is some new trend. When using a 3D printer, you can actually print out any object you like. And the main risk that this company was describing in this leaflet was that their assets consist by more than a half from intangible property, intangible rights, patents, and developments. And in this case, it is extremely important for a state to identify and to protect such intangible things. Now I'd like to give the floor to Mauricio Menzi, who will give us a European perspective of this new trend.
For the invitation and for the possibility for me just to come here and to exchange views with you. It's an honor for me to be in St. Petersburg for such a prestigious conference. Let me start by saying that after what has been said, I fully agree what has been said and underline the fact that for law it's difficult just to adapt to a situation which is moving very fast. We are facing a sort of disruptive innovation which highlight the difficulties of law to regulate everything. Everything is moving very fast, and for the regulators, for governments, for public bodies, it's difficult to find the right way to regulate, for example, new security issues, copyright online, data protection, and privacy, and so on. For example, the example offered by big data, I think, shows an interesting example of it. What big data is? Big data refers to data sets whose size is beyond the ability of typical database software tools to capture, store, manage, and analyze. The definition of big data is intentionally subjective and incorporates a moving definition on how big data set needs to be in order to be considered big data. We don't define big data in terms of being larger than a certain number of terabytes, thousands of gigabytes. We assume that as technology advances over time, the size of data sets that qualify as big data will also increase. So the main point is to take into account the fact that it's hard to imagine an international trade transaction that does not involve transferring data. So it's interesting to highlight which are the main points, which are the main problems arising from the treatment of big data. Let me start by saying that the most important question is who owns the data? That's an increasing, relevant, and yet largely unresolved question, whereas the answer, nobody can own big data, may not solve the issue. So there is a problem of ownership. Can anyone use data that is publicly available, and is it possible to claim ownership rights in structured data? Does the answer change for a massive accumulation of data entries, even if it remains largely unstructured? Another important issue is the one relating to privacy and data protection dimension. While big data is not limited to data protection issues, in many instances, personal data plays no role at all. Privacy concerns are nevertheless an important factor in any big data strategy. But let me recall also other interesting issues. For example, big data and database licensing. One of the possible forms of legal protection for big data is the sui generis database right, where an investment is made into systematically or methodically arranging data. A database right might exist which provides a legal protection for those that have made that investment to prevent third parties from commercially exploiting and transacting with big data. There is also a problem of copyright, the problem of security breaches, the corporate transaction. But let me highlight one basic point, which is the reference to the antitrust law. To the extent companies hold big data that are indispensable for the implementation of certain business models, they may be confronted with the request to grant third-party access to their data. And in this case, refusing third-party access to such data or discriminating licenses of such data may constitute an illegal abuse of the big data holder's dominant position and could result in civil litigation and significant fines. We are all aware of the fact that there are several types of data moving over international networks. I only limit myself just to mention the web browsing, file sharing, email, chat and messaging, audio and voice, video. Just to highlight the fact that the phenomenon of borderless data has enabled unprecedented efficiency and economy of scale in key sectors and for a myriad of businesses. As example, let me mention, social media and advertising, or for example, the case of telecommunication, enabling technology to ensure the transmission and processing of big data, raising potential issues around network management, net neutrality, data processing and export, or maybe optimization and strengthening of mobile and fixed network service offering to sustain the generation, collection, and transmission of big data and the Internet of Things. Some interesting example of big data application in practice is offered by the case of H1N1 pandemic broken out in 2009 countries in the Mekong Basin region of Southwest Asia. They tested a new regional disease surveillance cooperation program introduced a few years before, and participating countries, Cambodia, Laos, Myanmar, Thailand, Vietnam, and Yunnan and Guangxi provinces of China, sharing information on the spread and impact of the virus in their countries, including patient records and responsiveness to antiviral drugs and other treatment protocols. Which are so the barriers to free flow of information across border, taking into account the big data issue? I'd like to mention the forced localization requirements. Let me do an example. Vietnam is planning to impose a law that would require companies' web search portals, data centers, and cloud computing services to be stored within the country. Likewise, Indonesia has a draft law that would require all data carriers, including mobile phone providers and foreign banks operating in the country, to establish local data servers in the country. Venezuela, Nigeria, and if I'm not wrong, Russia have all passed laws that requires IT infrastructure for payment processing to be located domestically. One barrier is also offered by local data storage requirements. Let me do an example in this regard. Brunei, Greece, China, India, Malaysia have laws that require that data generated within the country be stored on servers within the country. Two Canadian provinces, British Columbia and Nova Scotia, have implemented laws mandating that personal data in the custody of a public body, such as schools, university, hospitals, and public agencies, must be stored and accessed only in Canada, unless certain conditions are fulfilled. These laws, in turn, prevent such public bodies from using foreign digital service providers, such as cloud services, in case where personal information could be accessed from or stored in a foreign country. Let me say something, a few words about what's the European point of view from the EU directive. The reference is given by Article 25. Article 25 of Directive number 95, number 46, which is going to be suppressed in a few weeks as soon as a new regulation is going to be adopted. It establishes some clear principles. For example, that member states shall provide that the transfer to a third country of personal data which are undergoing processing or are intending for processing after transfer may take place only if the third country in question ensures an adequate level of protection. The adequacy of the level of protection afforded by a third country shall be assessed in the light of all circumstances, for example, the nature of the data, the purpose and duration of the proposed processing operation or the operation, the country of origin, and the country of final duration, the rule of law, and so on.
Разрешите мне задать вам вопрос?
Can I ask you a question?
So consider the fact that there are strong implications concerning the regulation of cloud, the exchange of data by the clouds. Another interesting article which has to be taken into account, just to give a general and short overview of the European Union situation at this regard, is Article 3. Article 3, together with Article 25, establish the rule following that the directive shall apply to the processing of personal data, but shall not apply to the processing of personal data concerning, public security, defense, state security, and so on.
Давайте на этом остановимся, и я все-таки задам свой вопрос, потому что
Let us stop at that and let me ask my question. Now, how do we view here in Russia the big data? The most important for us to understand, in whom does this big data belong to? Is that the personal data, and is that protected by the secrecy of communication principle? We have a very clear understanding that as soon as the data becomes impersonal, and as soon as somebody gets hold of them, for example, Megafon, in the course of its activity, in the course of its operation, then this data becomes our ownership. And it becomes our property, and we have the possibility to manage and to deal with this data. And as far as I understand, this theory is still accepted by the court and is still accepted by the government. Another question is how long we can hold this position, and how long we can hold this ground. Does this information really belong to us, and whether we can really handle it in a more free way? What is the thinking of American regulators about it? That will be interesting to know, because there's no notion of the secrecy of telecommunication, because this notion is prescribed by the Russian constitution. In American countries and in European countries, there's a different notion. They protect the private life. We have a separate notion, a specific notion, the secrecy of communication, or the privacy of communication. And it has a more specific character, because private life protection is a more global issue. And with that, I'd like to give the floor to Mr. Butler, for him to explain to us how American regulators are viewing this issue.
And let me just add that I, too, am very honored to be here. As you allude to, the United States takes a very different approach toward privacy and data privacy regulation. However, we, like Europe, are going through a lot of struggles on how to deal with the vast technological changes of big data and other data issues that were just described. There was a report from the White House just at the beginning of this year that asked the ultimate question, and I think it's important, goes back to our first presentation, and it is, are the legal, ethical, and social norms sufficient to protect privacy and other values in a big data world? And that question focuses not on just the legal regime, but ethical and social principles that apply in this area as well. The US does not have a comprehensive data privacy statute, and therefore takes a very different approach than Europe and most other countries. You start with the proposition that the US Constitution establishes the relationship between the individual and the state government, and that various amendments, most particularly the Fourth Amendment, which protects against search and seizure, and the First Amendment, which protects freedom of speech and the right to association, establish limits on the federal government's ability to intrude on private life, and the Supreme Court has recognized and extended that right to a right to be let alone. As a result of that, a lot of privacy causes of action arose through common law state tort causes of action that protected one's reputation and prevented people from portraying someone in a false light. And along with that, various federal statutory regulations came into place to protect particular types of data. So in the United States, there are individual sector-driven laws that protect personal information, particularly when it deals with things like health records, telephone records, financial records. But the question is being asked now, are those laws sufficient in an area where we are operating in big data, data brokers, and data that goes beyond the control of the individual? As Anna mentioned, we call it the third-party doctrine, and it's a key pillar of US data privacy law. And that is that when I release my data to a third party, like a telephone company, I've lost my personal protection over that data. And this has come to light in the very controversial issue of telephone records and the electronic surveillance issues that are kind of in the forefront of the newspapers right now. We as individuals now give up so much of our personal information just to conduct everyday transactions. And what's being re-examined by the courts is whether that third-party doctrine on an individual basis, when I hand my personal information over to a telephone company or when I hand it to a bank, if that data is accumulated and used in the ways that were just described as big data, should that third-party doctrine still apply? The US is grappling with this issue through various initiatives. One is cybersecurity, and one would not automatically connect cybersecurity with a right to privacy. But the prevention of hacking and the release of personal information has become a very important priority because, as you may know through reading the newspaper, there have been some very serious breaches of databases held by things like retail stores or credit bureaus. And even though the statute protects that data, people have hacked into it and it's become released to the public, causing great damage. The White House very recently issued an executive order. It's voluntary at this point, but it calls for establishment of best practices in cybersecurity for critical infrastructure. So it's a reach out to the private sector to get together and develop best practices. Now, critical infrastructure isn't defined particularly, but it's outlined and covers many of the things you would think. Defense, electronic grid, water treatment plants. And they've they've turned to something called the National Institute of Standards to list certain core principles that companies and the federal government should collaborate on to establish best practices. And they are to identify sources of cyber breaches, to protect networks, to detect an intrusion, to respond to that intrusion, and then to have a recovery plan. This is all very new. It's in the works. It's only voluntary right now, but it's very much an evolving initiative. A second area is enforcement by the U.S. Federal Trade Commission. So the primary statute that is used in the United States to address breaches of data privacy is the Federal Trade Commission Act. And Section 5 of the Federal Trade Commission Act permits the FTC to enforce cases where there have been deceptive and unfair practices to consumers. And so the FTC is focused on the information that is provided to consumers about the use of data, and specifically the use of data by data brokers. As you probably know, there's a very large industry now that takes the data that you give to the primary person that you interface with, whether it be a bank or a shop or Amazon when you order something online. And data broker, but you interface, you know what data you're giving to them, and they provide you certain notifications about the use of those data, sometimes more transparent than others. But there's a whole industry that's come about as a result of this that takes that information, puts it into very large databases, and acts almost like big data in the sense that data is used to run algorithms and discover certain trends. And as was alluded to earlier, some of these trends are very, very beneficial. They're used in counterterrorism to identify potential targets. They're used in gene therapy to look at certain predispositions for certain types of diseases. However, they can also result in great risks to the individual because they can profile, they can discriminate. And so how data brokers are using this data to feed back to consumers for marketing purposes is very much a focus of the Federal Trade Commission right now. And they also this year did a report on data brokers that's calling for more transparency by data brokers with the consumer. Again, not a top-down regulation like a comprehensive data privacy statute, but an attempt to create more transparency, to give consumers the right to opt out, to correct information, and when a strong enforcement mechanism that where these laws are breached, high fines are being paid and injunctions and consent decrees are being imposed. So it's a different approach, sort of a bottom-up approach, but grappling with the same issues of having the law try to catch up with these tremendous changes in technology.
Спасибо большое.
Thank you very much. And in that respect, I have a question. Of course, the United States is the flagship in creating and processing such data. But as we all know, there is a common rule according to which the consumers are protected in the country where they consume the service. However, in the case of big data or services that are available on the web, it's very difficult to find out what is the country where the service is consumed. You know the cases of Skype and other OTT operators where countries try to regulate their operations, like France that talked to Skype and said you must pay taxes in the country from where you get the services. And we had similar discussions in Russia, but unfortunately these companies do not pay taxes in the companies where they render services, and probably on the one side one can talk about whether the state can establish such control, such rigid control, to provide on the one hand security and on the other hand the protection of national interests. And certainly the question arises of the companies that aggregate huge amounts of information that they later may use. And I would ask Yanis Leonis to briefly cover the issues related to anti-monopoly, antitrust law and regulation related to processing such information.
Thank you very much for your invitation. It's always a pleasure to be here. Before addressing the antitrust issues, I think I would like to comment a little bit on what has been said before in order to give some context in our discussion, in particular in view of the first presentation. Now, we heard about this emphasis on categorization in the sense of, oh, you know, is it a property right or it is not a property right? And, you know, there is a narrative basically of propertization that comes out, and you can see actually it's a trend. Now, you know, why, you know, the idea that the fact that I am going to the supermarket online and I'm, you know, ordering for this particular brand of cereals, or that I'm buying the 50 Shades of Grey book through Amazon, is an information that somehow, you know, at some point got value. So, and this process of getting this value created also this idea that we should talk about the property right in this particular case for this type of information. And obviously, that is a very recent process in a way that you have firms that came out of nowhere, startups a few years ago, that acquired huge value by actually collecting and managing this type of data about our personal preferences and behavior on the internet or social media, or the fact that we liked one of our friends' post on Facebook about a particular thing. And it's actually a lot of money, if you think about it, when you look to the value that some firms are providing in order to acquire other firms that get this particular type of data. I mean, we're all familiar with recent merger stories, the Google kind of merger frenzy, and obviously the amount of money that this might provide. So in a way, we can, the European Data Protection Agency had a report a few months ago where they were providing a figure about the value, the digital value of that particular data, and they were saying that it's about 315 billion euros. They were basing this particular evaluation on basically the price that is offered to buy these particular companies and the number of users of these companies. So they were basically estimating that the income per user per year will be between 3 and 5 euros. And obviously you multiply the users, you multiply the value of that, and according to the European Data Protection Agency, that value will rise to 1 trillion euros by 2020. So we're talking about a lot of money. Now, you can also see the way the companies are basically somehow behaving, the companies active in this particular type of data collection and management are their strategies, their commercial strategies. I mean, think about Amazon, for example. Okay, you may think that Amazon makes money out of the selling of books. However, I mean, if you think about it, most of the publishers right now, they have online services where you can get basically the book directly. You don't really have to incur inventory costs, and which was basically the main reason why Amazon was really, active and somehow successful. So if you think about the current business model of Amazon, you'll say that the company basically is going to be bankrupt in a few years' time. However, what do? I mean, they expand in other type of services. They want to become a sort of virtual supermarket, where you can buy basically clothes, you can buy books, you can buy anything. And obviously, they collect a lot of data out of this thing. So their competitors are also changing. I mean, for Amazon right now, the competitor is not the bookstores. I mean, the competitors are actually other companies that are collecting this data from users, and obviously, that also leads their strategy in a way. I mean, we created in London a few years ago the social media unit at University College London, where we meet regularly for dinners with a number of key players in the social media industry, and so bring people Facebook, Twitter, etc. What was always surprising to me is the fact that to let them talk and see how they think about their competitive strategies. And in a way, you may think that some companies that one will not necessarily conceive as being competitors, but not being in the same market, they are competitors from the fact that they are trying to connect with as many users as possible, and obviously their strategy is to diversify, let's say, their offer, and in order to be somehow in connection with different users. Now, that said, I think that a quite interesting element of interconnecting a little bit this private law approach on property rights that we had from the first presentation, and a more public law perspective that will focus on the social function of property, or the limitation of property rights, is the fact that privacy laws are basically a way for us to provide value, in a sense, to some data. The fact that someone says that, well, the data that you generated by visiting this website is privacy, so it's your thing, all right? That obviously, provides a value and proprietizes it, because it provides you a possibility to exclude others from using your data. And if you think about it, for lawyers, property is basically linked to exclusion, to excludability. For economists, it's a little bit different, although excludability is basically an element of the definition of what could be a private property right. Public goods being actually non-excludable and non-rivalrous consumption. By opposition, you can exclude someone that is creating some form of proprietization. So privacy regulation actually feeds in this process of proprietization. Because obviously what we say, what this privacy regulation says, and we'll look basically to the Data Protection Directive in Europe and the regulation, it doesn't prohibit others from collecting data. I mean, this is absolutely legitimate to do. It regulates the use of that particular data by asking for the consent somehow of the user. And obviously, we should think about this express consent. So in a way, if you think about it, it tries does a little bit like contract law, somehow tries to regulate the transaction and make sure that we have, some form of ability to regulate the way actually that this data, this resource, this asset is going to be used in the market. For example, if you look to the Data Protection Directive, they basically say that personal data must be collected for specific, explicit, and legitimate purposes and not further processed in a way incompatible with those purposes. The question being, what is incompatible use with the purposes? And obviously, there we have some interpretation by the Article 29 Working Party, which is basically there in order to interpret the implementation of this Data Protection Directive, saying that compatibility should be assessed in the light of the context in which the data were collected, of reasonable expectations of data subjects, of the nature of the personal data in question, of the impact of further processing, and of safeguards to protect the data subject. So in a way also we see, and this is something more present in the new basically regulation, the project reform regulation, the idea that the individual might actually get a right to obtain a copy of the data processed electronically, including, for example, his social network profile, purchase and search histories, and to transmit it to another automated processing system. Basically, the idea will be, let's say that there is, through smart metering, you might collect data about your use of energy. You can basically require some sort of data portability, let's say, kind of right, which is pretty common in telecom, to provide that data to a third party that will advise you on what is the best provider in terms of costs for your energy use. So in a way, what we see there is not a prohibition of the use of that data, but it's basically an empowerment, let's say, of the individuals to use commercially the data for their own purposes. So in a way, we are in a bargain game where we provide, we know all that we are, when we use a search engine, it's free. I mean, Google doesn't impose us a price, although it has a cost. What they provide to us, marginal cost is very, very low, but still there is a cost. We don't pay anything, at least as money, but we pay privacy. We pay information, personal data. So that's the money of exchange. And I'll come back again to this issue when we discuss with antitrust, because I think it poses considerable issues with regards to how antitrust will be applied when you don't really have a price, or the price is actually, is basically data, personal data. So in a way, we see this process of proprietization. So from the other side, of course, we have this question about, well, should we rely on the individuals to, basically, we give them a property right on their data, should we empower them to use it the way they want? Some of us will exchange their privacy for services that they value, and I would say one could probably think that this is very good. I mean, this is what they want. Why should we come and regulate that. So that could be, let's say, the idea, and the same type of issues come after also with regard to consumer protection. I mean, should we protect the consumer, the stupid consumer? At the end of the story, I mean, they are free, they have autonomy, they can basically go and do whatever they like. But at the same time, a different perspective would be to take a sort of libertarian, paternalistic type of perspective to say, well, individuals might not necessarily know very well, be well informed. There are a lot of deficiencies in the way they're thinking, and the role of the state is, however, there to protect them somehow and provide them, an informed choice. And in a way, that will bring in aspects of consumer protection as well as antitrust in regulating basically the use of data. So in a way, a private law type of issue of property rights will become a public law type of concern of, of state intervention and legitimate-based state intervention in order to regulate the use by the individuals of this property that they have on their own personal data.
Спасибо. Да, мне кажется, что вот здесь эволюция отношений.
Thank you very much. I think that the evolution in respect of the attitude to big data and personal information is similar to the evolution of the property right in general. We proceeded from the absolute right and absolute prohibition. We focused on protection of personal information, and now all the states, I think, and super-state bodies have recognized that this is an obvious economic use when we use it in the turnover, and we have to maintain it. And it is not detrimental to the citizen when they use aggregated data. So take into account these evaluations and high figures of $1 trillion according to future cost of the company. We might say that the state started supporting and providing certain incentives to the turnover of the data. And I would like to give the floor to Mr. Mark Dalvitton, who will present his vision. Большое спасибо.
Thank you very much for having us here and participants and panel. I'll try to address basically two issues, given the wide introduction to the theme that has been made. There are some slides that are following. If the command can follow, will be great. We have seen the general introduction, and I may concentrate on two topics. One is the impact of big data on consolidated legal institutes. The other one is what value is being created by big data. Now, we have seen the classifications, the players, the rights, what are the elements that fall in place, what are the characters, perspective, and we have heard of a number of cases discussed in the States. That's a recent FTC chart on data brokerage that drives us more or less remotely to the point that I would like to touch, which is the following. Now, in terms, I would like to touch, in terms of consolidated legal institutes, two items: limitation of liability and proportionality. Now, and I would like to use, in a way, big data to challenge some of, or to try to challenge some of fairly consolidated jurisprudence and way of thinking, starting from the e-commerce directive. And on the first point on the slide, the theme that I would like to touch is if a quantitative approach can be still deemed to be acting as an exemption. We have seen tons of jurisprudence in terms of e-commerce based on it is so much information that it would be unreasonable to assume that a control is possible. So you have this theory on one side versus indexing of every search and penetrating cookie distribution on every second of search. So my point is, can you as a regulator, can you as a legislator still maintain that quantity is an exemption in terms of limitation of liability, but it is necessary, on the other hand, an indispensable way of proceeding for the industry on every second basis? Every second indexing, caching, treating, restructuring, delivering to the public is made as an action of an OTT. And at the same time, there is a presumption of conduit of an empty hole, an empty tube without any responsibility. Is the second point still standing? Is this industry really alien from content? Is the conduit limitation in the second bullet versus indexing, mapping, selecting, filtering, assembly still standing? Is it possible to have a conduit catching, hosting proposition, as you all very well know, in terms of e-commerce, assuming that you don't touch, assuming that you don't store, assuming that you don't knowledgeably treat, so on and so forth, you're not responsible. And is that assumption still standing against a major OTT statement whereby the mission is to organize worldwide information to render them accessible, and a number of social scopes of a number of search engines on a European worldwide basis do still represent the word editing and publishing in their Chamber of Commerce filing? So this point is not against or against the OTT or in favor of telcos. It's just trying to see if the legal doctrine that has been put at work until today stands, and in my view, it does show some very, very serious faults. So this is first item of limitation on liability in terms of which impact. The second, in terms of proportionality. So it's wildly too much of an ambition to try to treat it in brief, but to just the idea of trying to rebalance the private, public, national, transnational balancing of rights that we have seen very recently, from the right to know, the right to be forgotten, the right to access, the right not to access, opt-in versus opt-out, I think is boiling down towards almost a constitutional delegation of powers, and definitely the Google decision of a few weeks ago is in this line. A delegation of powers to a private entity of constitutional powers, that is something almost unseen in this industry before. Going forward on my second theme is value. We are seeing data that had previously no value acquiring value. We have seen data that was not deemed as data being treated as data and acquiring value. We are seeing data that was unrelated, that's now it's related, and the relation in itself is a value. We're seeing units of data and units of correlation acquiring value. So just to come up with an example, a slightly commercial example out there, we are showing three numbers of what the market is considering as a tradable data. The first data with following the market consensus, 15 euros. Assume you have two sets of that data, so you have 30 euros. Assume you have a correlation of data between the first and second set of data, and the market basis is approximately 20 euros. So you have a first set, a value, a second set value, and the second set value is acquired by way of a correlation. Neither the initial value, neither the second, neither the third, the correlation existed without a set of implementation of big data or correlation of the same. So in terms, just as a conclusion, we're seeing I think, major impacts that need to stem very radically away from what has been a quantitative approach towards a qualitative approach. And we are seeing the empowering of raw data and the correlation of new data as a new currency. Thank you.
Спасибо большое. Хотела бы вернуться немножко к вопросу.
So I would like to come back to transition from global problems and supranational regulation to how the state looks at these data and these limitations. And I would like to address the experience of Germany and to give the floor to Nils Lutskov, who will discuss the German experience and how is it possible. Coming back to my question, I don't believe that it is possible to effectively at this state regulate the data turnover at the national level. And for instance, I gave a poor experience of France with Skype. Probably in Germany, this experience is more lucky, and we managed to find a certain recipe. We don't have that in Russia so far.
Anna, thanks a lot for the invitation. I'm glad to be here and to participate in this challenging debate on data protection and data privacy. In fact, before turning to sorry, I think I should talk to the micro. Before turning to German cases, let me give you a brief outlook on what we might call, well, Europe is moving at two different speeds actually. On the one hand, there is the supranational level, meaning the European Union and the case law by the European Court of Justice. On the other hand, there is a certain reluctance based on texts that courts have to apply to afford a similar level of protection within the member states. Let me get back to this idea in a minute. These are the relevant texts that the ECJ needs to apply. And actually, from a constitutional perspective in Germany, but also in other member states, these are two distinct concepts. The one concept being protection of private life, so a more substantive right against intrusion of the press in your private lives. On the other hand, a more procedural right, which is set forth in Article 8 of the European Charter of Fundamental Rights, the protection of personal data absent an informed consent of the individual. What the ECJ is actually doing in recent days is merging those two rights and creating a very powerful right against both, against state intervention and against private operators, so to say, against the market forces. Just briefly, three different cases. Cases where the ECJ did something very exceptional given its reluctance to strike down legislation on account of violation of fundamental rights. Well, it struck down two regulations. One is a regulation on agricultural subsidies. This regulation failed to duly account for fundamental rights under the Charter, in particular data protection, since data relating to subsidies, relating to individuals, had to be disclosed, who got what amount of money from which particular fund. And there the ECJ said that limitations of data privacy and data protection have to be strictly necessary, and this is something that the EU legislature needs to positively establish, and there's a heightened level of scrutiny, like in the States, probably something like intermediate scrutiny, and not only a rational basis test. Another case, the Google case. This is not about state intrusion, this is more about private entities. And there the ECJ said that an individual may have a right to be forgotten after 10 or 15 years or even more, and said something very remarkable, which is underlined at the bottom, that the rights of the individuals in keeping their data private override, as a general rule, on the one hand, the economic interest of the operators of search engines, but on the other hand, those individual rights to their data protection also overrule the public's right to know. And this is reflected somehow in another ruling, the UPC Telecable ruling concerning an Austrian case in Vienna, where the ECJ said for the first time it may be licit to block access to websites, to, for instance, streaming websites, if those websites infringe upon copyrights. And in Germany, this is something unseen thus far. No court has ever granted an injunction to block access to sites. Okay, so we see here that there is somehow heightened level of protection of personal data, which can be enforced against those who are actually marketplaces of data, like intermediaries such as access providers. Let's now have a look at what's happening in Germany, which, well, we will see courts are way more reluctant to enforce those rights. Facebook, 3 cases on Facebook actually. The first case concerning an order which has been issued by a data protection authority. A data protection authority ordered the disconnection of a fan page. So this was not Facebook itself, this was an operator of a fan page. And the court bluntly said, well, actually, if you have a fan page on Facebook, you do not process any kind of data, and you do not order anyone to process data, because you are in no way responsible, you have no right to control, and you have no factual control over what Facebook is actually doing. So you basically cannot act against those third parties who are actually benefiting from Facebook's offers on account of data protection laws. This is one thing. The other thing is, it is tough for public authorities to act against Facebook itself. This has been highlighted in a recent case where a data protection authority in northern Germany acted against Facebook and claimed a violation of data protection laws because Facebook disactivated your account if you failed to provide all necessary data which was required by Facebook, including your real name, your real email address, your real date of birth, and so on and so forth. This order has been quashed by an administrative court since, well, the argument, the reasoning was very simple. The authority in Germany has no jurisdiction, has no authority, since Facebook Germany does not process data on its own account, but rather Facebook Ireland. So the subsidiary of Facebook Incorporated, which is located in Ireland, processes those data so that the authorities located in Ireland have exclusive jurisdiction to enforce data protection laws on Facebook. So this is somewhat a setback for the public enforcement of data protection laws. In order not to give a picture which is too grim, let's have a look at what individuals can do or what consumer protection associations can do. Final issue I'd like to raise here. These are way more powerful since they can challenge the general terms and conditions which are used by Facebook. They can go to court, not to administrative courts, but to regular courts of law. And those courts are willing to step in, arguing that oftentimes the terms and conditions are not clear enough, so there's a lack of clarity on the amount of data you're willing to disclose and to make accessible to others. And this is not up to the standards that are in the Data Protection Act, and this is not up to the standards actually that apply in general civil law under Article 307 of the German Civil Code. This is one aspect. And through this aspect, the Regional Court of Berlin managed to quash or managed to grant a preliminary injunction against Facebook for the Friend Finder application. So Friend Finder, what's that? So if you register on Facebook, or this was 4 years ago, if you registered on Facebook in 2009 or 2010, Facebook offered a feature to you, namely to have access to your email account, let's say on Outlook or virtually any other program you're using, and to retrieve those data in order to suggest friends to you. You might know this one or you might know that one. But the problem here was that it was unclear whether those friends were actually on Facebook or not. So what Facebook did, Facebook sent invitations to persons that had not been registered on Facebook thus far, solely because they were in your Outlook account. And that was a breach of law, and that could be enforced through the regional courts. And finally, there was something like an IP clause. You grant all kinds of IP to Facebook. They may use your any content you post there. And finally, they may also use your profile picture and name, I quote, in relation to commercial communications. And there the court again said, this is too broad, this is overbroad and too general, no one exactly knows what this should denominate. And so as a consequence, Facebook had to change its general terms and conditions and now to specify what exactly means use your name and personal data in relation to commercial communications. So you see that there is ways of enforcing data protection rights at domestic level in Germany, but you also see that there's a deficit of enforcement due to problems of jurisdiction when it comes to public law enforcement through public authorities. And this is slightly different to the speed we actually see when assessing ECJ case law. Thank you.
Спасибо большое.
Thank you very much. And your presentation confirms my idea that unfortunately on the national level and from the standpoint of public law, there is no effective control of internet. And so the governments are trying to set up new limitations in the internet by nationalizing internet. I don't know whether you know that or not, but recently there was a publication in the Russian media about the initiative on national internet. This supposes a hierarchical system of internet, which from my viewpoint looks an archaic requirement. The second requirement is the transfer of a DNS server to the territory of Russia. You know that Russia has no DNS servers. The next measure is a registration of domain names in RURF and SU. And I'm not even talking about the national security issues, which has been already touched upon in relation with, or touched upon by my American colleagues, but Russia also has a number of quite serious requirements to internet operators. And in this case, I propose that we discuss it in a free discussion. Let us discuss whether the nationalization of internet is an obvious trend, and whether you think that trend will provide certain results, and what we are to expect, what levels of regulation we will achieve through this. Paul, I suggest that since you are an experienced expert, you start.
I'm not so sure on this topic. It's a fascinating one, but one that I don't know that it's achievable. And that may be because as the elephant in the room, the United States doesn't want to see it happen, because we, I think, appreciate an international internet because we have such a running start. I'm afraid I'm going to defer to one of our other colleagues on this topic, though. It's not an area that I really can speak to right now.
Но вот
But the issues of cyber security is also a move towards a national regulation. You're just calling it a different word. while in reality it means limiting access, it means control of the circulation of information. It's the other side of the medal, so to say.
That's definitely true. I think, though, that once again the focus has been not on the sharing of information, but both on the defense of networks and on the creation of new technologies to disrupt cyber attacks, which is one thing that was a focus of some of the U.S. reports recently that are grappling with this issue of the loss of privacy, the loss of control over the internet, and the attempt to try to nationalize what really is an international cross-border phenomenon, is a somewhat overlooked ability of technology to outpace the problem. And again, I'm entering an area that I don't know a tremendous amount about, but I think we need to focus ourselves also on technology as the answer, not only as the threat in these areas. And there's a lot of work, a lot of research and development in that area, particularly in the cybersecurity area in the United States.
Спасибо. Вот Янис, да.
Thank you. Yanis, I will pass the floor to you.
Expert on this topic. However, I will claim that the trend is actually not towards nationalization, but towards basically extraterritorial application of the national laws. In a way, it is basically, I think futile to think that by nationalizing internet, you're going to be able to control it. Actually, what happens is that everyone takes stock of the fact that this is an international it's an international, basically, exchange. And the question will be, can you apply extraterritorially your own legislation in order to protect the users that are based in your territory? And you can see there some evolution in the EU, for example, the former, the actual now directive, which is going to be replaced by the regulation, was saying that EU data protection law applies equally to all data controllers established in the EU or using equipment situated in the EU. But if you look now to Article 3.1 and 3.2 of the regulation, well, EU rules will be extended to any data controller, I quote, offering goods or services and monitoring the behavior of data subjects residing in the EU. So much more, in terms of extraterritoriality, it will expand considerably the scope of the EU regulation. And quite interestingly, the European Parliament clarified actually the scope of these articles by saying that this will apply, this offering of goods and services, I quote, irrespective of whether connected to a payment or not. So from that perspective, that actually offers a quite important boost to EU competence in this particular area. So I would say, I think nationalizing the internet actually is probably going the opposite direction. And what is happening right now is, we're trying to impose regulation, which in this particular case obviously protects, it provides data protection, extraterritorially. So maybe this is going to be the trend in a way, at least for data protection purposes.
Спасибо большое. Надеюсь.
Thank you very much. I hope that we, the Russian Federation, will join this trend and won't try to invent a bicycle and to invent some institutions that restrict the turnover of the information. And we'll use that experience with great pleasure. Now let us come back to the issues of anti-monopoly regulation, which we discussed previously, but we haven't yet finalized the discussion. And probably I will start with Yanis once again.
Thank you. So for antitrust purposes, for competition law, this area is extremely fascinating, and I would say almost quite new, because obviously we have some interesting issues arising with regards to how to think about this particular markets. Now, let's say that most usually these are two-sided or three-sided markets. I mean, what do I mean by that is that basically you have obviously the relation between, let's say if you think about the search engine and the user, so that's one side. And as I said before, the users are not paying for that particular search engine. I mean, you're not charged by Google or Bing, etc., for a particular search you did. But then you have other sides as well. I mean, the most lucrative side for Google, for the search engine, is the relation with the advertisers. And obviously, you know, they are charging a price. And also, there is a third side is actually the relation with content providers as well. You might have competition concerns that arise in all these different types of interaction between all these different sides of the market. I would say that from an antitrust perspective, and focusing a bit more on the big data issue, the control of this huge amount of personal information might contribute to enhance market power in the digital economy. It might actually enable firms to expand their market power and obviously exploit consumers. And from that perspective, in a way, that might be a competition law issue. Secondly, if you, from a point of view of consumer welfare, why? Because consumers are not only interested in price, privacy, might also be a concern for them, a parameter of competition, and therefore we have to think about how you can integrate this privacy concern, this preference for privacy as a parameter for competition. Obviously, a possible way to deal with this issue is to have a number of, let's say, privacy-enhancing services market, where you have search engines, for example, that are somehow identifiable by the fact that they are providing high, privacy type of compatible services. But obviously, you might have issues with regards to that. For example, you have a merger and you have concentration that might, create risks for consumers that, would like to be able to choose between different search engines, for example, that some of which are more, evaluating privacy more than others, even if, the consumers has to pay something for their particular use. More specific problems, I would say, are, for example, if you think about mergers, I mean, obviously the first concern is the merger of a community dimension? I mean, are we going to apply EU merger control? And we have thresholds, which are basically turnover thresholds in regulation, in the merger regulation, which trigger its application. Now, in this particular case, however, a turnover is probably not, because the data is basically offered for free. I mean, we are actually, using the service and we're not really paying for it. So, the turnover might not necessarily represent the power, the power that this company has on the market for data, personal data. So from that perspective, if you rely on the classic turnover thresholds, that might create a problem. So maybe, in this case, you'd probably be better off with market share thresholds. If you define a relevant market as being the relevant market for personal data, all right? So for example, Google will, have 60% of that particular relevant market. Now, the question is, how can you define a relevant market of personal data? I mean, is it going to be a relevant market for, let's say, data used for the X purpose? And that particular purpose being basically in defining the relevant market. So obviously, for example, data targeted to advertising. So that could be, let's say, the element that will enable you to define a relevant market and therefore to compute and evaluate the market share of the firm which will trigger, the application of the merger regulation. So these are, I think, open issues with regards to the application of merger control in this particular context. Now, obviously, you have a number of substantive antitrust issues that might come in terms of restrictive practices that might come also out of this particular type of area. For example, I mean, you're probably familiar with the recent Google cases, antitrust cases in both the United States and in Europe, where actually the Federal Trade Commission in the US and the European Commission have taken different directions in a certain way. In January 2013, the US Federal Trade Commission found that basically, I mean, with regards to some allegations that Google had been biasing basically their search results to favor their own products and services, actually services, in comparison to their competitors. The FTC found that there was not really any particular information, evidence about this type of practices justifying legal action by the Federal Trade Commission. And also the FTC found that although Google had taken aggressive actions, I quote, to gain advantage over rival search providers, the FTC's mission is to protect competition and not individual competitors, and therefore they thought that these practices did not violate US law. Obviously, Google had to provide some form of commitments here, very informal obviously, because they accepted not to seek injunctions to block rivals from using patents which are essential to key technologies that could lead to the foreclosure of competitors, and also to remove, and I think this is quite interesting for our purposes, restrictions hampering advertisers' management of their ad campaigns across competing ad platforms, which I think is a common concern for both Europe and the US. However, in Europe, I mean, the situation is different. I mean, the Commission is considering, I mean, there has been a proposal for Article 9 commitment decision by Commissioner Almunia. This is obviously a matter of, I mean, there has been some opposition from other commissioners, etc., so we'll see. But the Commission actually thought that, well, there were competition concerns, actually 4 competition concerns, and that somehow, the Commission had to intervene and impose some commitments. I mean, commitments are not imposed by the Commission, are proposed by Google, but obviously, there's a bargaining with the European Commission, and, Google is bargaining under the shadow of an Article 7 infringement decision, which in this particular case could have imposed to Google a fine up to 5 billion euros. So obviously, they had to be quite open to the proposals of the Commission to settle. And with regards to that, I mean, obviously there are different concerns, but one of which was the fact that Google was imposing limitations to portability of online search advertising campaigns from the Google service, which is AdWords, to other platforms of competitors, and the Commission basically, somehow Google accepted, after the Commission's pressure, to no longer impose these obligations that will prevent advertisers from managing, let's say, different search advertising campaigns across different platforms. So basically what the Commission actually is trying to do there is to enhance multi-homing in a way, the possibility for an advertiser to have it use different search platforms in order to promote their services. And I think, this indicates somehow this idea that we need to bring more rivalry, more type of choice to the consumer in this context. Now I think that apart from these aspects, of, let's say, purely antitrust related type of aspects about how we're going to define market power in this context, relevant markets, the thresholds for the merger regulation to apply, practices of abusive practices that are not necessarily, I mean, at least for an antitrust law perspective, I mean, they're not necessarily that much related to antitrust. It's more kind of a sort of fair competition / antitrust at the boundaries basically of the two areas, I think a very important issue is how antitrust will interact with consumer protection. And privacy regulation. There has been a quite interesting report by the European Data Protection Agency back in March this year, 2014, where the connection between these three areas are actually examined thoroughly. And it is proposed that regulators, the Commission, which is a regulator for antitrust, the main antitrust force, obviously the national competition authorities, European data protection, the European different member states data protection agencies, as well as consumer protection bodies should somehow communicate with each other and should develop a more holistic approach with regards to this big data type of issue. I think that would be extremely challenging to bring all these three communities of lawyers and regulators together. Some competition lawyers feel that we should be very careful as competition lawyers to embrace public policy concerns like privacy, etc. In our, let's say, in the way we implement competition law. There is a risk that, some form of, the idea that if you develop a very broad perspective on what consumer welfare is and you basically put everything there, that might lead to problems with regards to the application of competition law and the predictability of the rules, and obviously, the way that different firms might somehow prepare themselves and comply with these particular rules. But obviously, we see that there's a lot of pressure from the public, and that leads the regulators to respond by having this kind of more interconnected approach with regards to these three areas of law.
Спасибо большое, но мы опять вернулись к...
Thank you very much. We have come back to the basic discussion concerning what the state should support, the economic turnover, and on the other hand, the rights and freedoms of a man and citizen. I would like to know your opinion as to what viewpoint will prevail in near future, and what will be the main focus of the regulators. Marco, what do you think?
May I ask on the specific antitrust point or more general? All right. I think that we will be seeing talking and addressing the extraterritorial point that was made and the inbound approach of a number of internal revenue services throughout Europe. I think we'll be seeing a balancing of the extraterritorial versus denationalization, not only driven by privacy, but by internal revenue services agencies. And this is a fact. The structures that we have, and this is going to alter all sorts of business models, be it the cloud, be it the delivery, be it the notification of export in a US, in a EU, or in a safe harbor US domicile. This is going to blow up a whole bunch of things, starting from Ireland, definitely. The assumption, the structures that have been put in place, the single Irish sandwich, this double Irish sandwich, the Irish sandwich mixed with the Irish Dutch bounce back option, these can't be put on a table in front of a certain civil law jurisdictions for 10 minutes. This is a fact. And this means a piercing of corporate veils throughout Europe and a full attraction. This means a total reevaluation of the transfer pricing schemes and modules and values that have been put there. This means that in terms of antitrust sanctions, what has been deemed to stop at a single jurisdiction invoicing 50 million a year is going to explode against a percentage filed against 5 or 6 billion. So 3% sanction against 50 million is going to become a 5% sanction against 50 billion. This has already happened. There are examples. There are examples, fairly incredibly, where I may omit now the direct references, where the single general manager of the single jurisdiction with 12 million euro per year just said, no, we're not providing, with the finance police investigating after a 5th or 6th day, with written records, at the 6th day, the general manager said, no, we're not providing the service out of this place, but this service is being provided out of Palo Alto. The difference was in excess of 3 billion. So what was supposed to be 700,000 euro sanction became in excess of 200. Just by one line on a written record on the sign in that single moment. So this is a big driver, in my view. And this is unfortunately going to prevail. And it's going to kill all a number of other assumptions. We're making an effort in getting to a different generation. We're still very much quantitatively oriented. A number of OTT players are taking the view that the sales guarantees in Italy and in Europe and France and Germany do not apply. That means a 2 years guarantee. Oh, no, we're going to accept 4 months. Okay, they get a 1 million, they get a 5 million sanction. They keep on going. Lawyers desperate on their side. So in as much this approach is going to be kept of entire lack of communication, there is no possibility of switching to a 2.0 or 3.0, let alone a 3.0 that we've been discussing. Obviously, data is a currency. Data should be, there are a number of companies that should be regulated by a central bank, not by privacy, and that should be a correct way of looking at it. But that's not even in 10 years' time. So some little players on the side are going to explode in the positive sense, but from my view, fiscal and privacy in a prehistoric approach are going to still fly. I would love to see must carry, a full portability, a full definition of a wholesale pricing for certain intermediate aggregated set of non-belligerent data. Impossible. So, okay, in terms of theory, I would love to see them. We've seen Market 15 for mobile being killed. It's not in the interest of telcos. It's not in the interest of mobile virtual operators. We have 7 markets left. Players. We are seeing what we're seeing here. And one last comment. We're seeing analysis of cookies and investigation on cookies. An allowance of 12 months to say, get your cookie stuff in order, so an amnesty. At the same moment, you're carrying out investigation of criminal and civil relevance, but you're giving an amnesty on 12 months on cookies that everybody are using, and you're waking up on cookies 15 years after. So who needs jurisdictions and authorities that wake up in an industry 15 years after trying to rule something that's plain vanilla?
Anna, can I add a brief comment on a similar topic and on the general question of where regulation is going? And in the U.S., you see some trend away from the collection of data with a recognition that the law is just never going to be able to catch up with technology in that area, but a focus on the use of data and using laws, privacy laws, discrimination laws. To use an example of particularly what we're talking about, if my bank transactions, my telephone transactions, my store transactions add up to a profile of me when they're all crunched together in a big database, and they say, well, I bought a minivan, I stopped at the sports store and bought 3 soccer balls, I stopped at the clothing store and I bought children's clothing. That paints a profile of a soccer mom, that what we call in the United States, that people target advertising towards. If I add in a transaction at the liquor store every day, it creates a different profile that can be used to deny someone car insurance, for example. And I guess the big issue is, for example, like gene data, right? So in order to identify problematic diseases linked to gene therapy, you need large amounts of data in order to be able to identify some particular trend. And that can help create cures. It can also lead to the denial of health insurance, or at least up until Obamacare it could. And so you see the problem. And so what the focus is trending towards is, how do we control the use of data and direct it towards positive outcomes and away from negative stereotyping, profiling, and harmful results. And I think that's where the trend in regulation in the United States is going.
Maybe, I think if I'm not wrong, the recent reform adopted by President Obama just goes in that direction.
Yes.
If I'm not wrong.
Yes, that's it. I mean, there's a great debate going on because the collection issue obviously dates back, and I promised I wasn't going to drift into this very controversial area, but the whole National Security Agency collection of phone records. And so there's a real a debate about that issue with large collections of information and link analysis connected to all of that, which really does in a way fall into the same category as these records are going to be collected, they're available, they can be used for good. What laws and regulations can we put in place that will prevent them from being used harmfully? And but still, there's a lot left to be said about that. It's easier said than done.
Спасибо большое.
Thank you very much. That was very interesting. Although, if we look at the two latest comments, Paul is rather talking about the interests of the state and protection of the citizens, while Marco is talking rather about economic trends, taxation, and so on. Actually, there is still no common point, and we still have to find a point where we could balance those two areas of interest. And I think we've been talking a lot about different aspects of those tendencies, but I would like to come back to Dmitry Dozhdev and to his outlook of whether these phenomena that we are discussing, whether they are things, whether you can define whose right of property, and whether there is property right here, or are we talking about some subsidiary products that allow companies to better sell their services, their mainstream services, and how all that fit the classical theory of right? Thank you. Well, I would single out several issues here. Actually, there's a lot of issues, but one issue that I want to do away with at once is the reciprocality of relationships between the user of a search engine and the search engine itself. I heard that this is a free service. Well, that is not a free service. It uses my time, and apart from searching, I get a lot of information I don't want to get, and there is an issue of mere participation. You have to understand how the network works to formulate the issue of reciprocality correctly. And the second issue is the contribution of an individual into that aggregated data. There is no contribution, in my opinion. I preset the analysis, and I'm only interested in myself, and then there is no contribution at all. I don't understand what the white blood cells are. I need the MD to understand that, and when my general practitioner understands that, he will prescribe me a remedy. And when you analyze millions of analyses, a new medicine may arise. But there is no there isn't my personal contribution into that analysis. And if I'm of interest to many people, if I'm someone, if I'm a person, such a person that many people want to know the results of my analysis, you may raise the issue of protecting data because there is a value in the data that I supply. So the urine of a genius costs a lot. But that has nothing to do with data collection, and it has nothing to do with big data. And I would keep those issues aside and not mix them up with the problems that we are talking about. And it seems to me that the conclusion that was already made several times, or a position that the aggregated or big data is inevitably depersonalized, provide an answer to this question, to the question of whether an individual can control that data. And I believe he cannot, and there is no possibility for that. And finally, those who get the information by analyzing the big data invests huge amounts of money. You need a supercomputer. You need to ask the right question, and you need to have a consumer who is capable of working with that information. On the level of an individual, this is impossible. So this trend towards big companies that would have a free hand in working with big data is well justified. Thank you. Thank you. If anyone wants to ask a question, I think you have an opportunity for that, but if there's no more questions, I would continue asking questions to the speakers. Suppose we agreed that despite our desire to protect the citizens' personal data, the big data is not personalized, it's aggregated and are processed by different participants in the market. We gave examples of how Facebook reached the data in the Outlook of a person and then sent invitation to that person. We see an example of telecommunications operators who provide over-the-top services like Skype did, and by using the data from a notebook of a person, they deprive the traditional operators who pay taxes in certain jurisdictions and who invested money in the network, they deprive them of a possibility of earning money on their traditional center. Well, and then we're told that the company WhatsApp is registered in Palo Alto or in Ireland, but it's certainly not under Russian jurisdiction. And the fact that it takes your money, well, unfortunately, we can't do anything with that. You have to live with that. And then when we discuss antitrust issues, WhatsApp was recently acquired, and there's no limitations. There were no limitations imposed on that company or on the purchaser of that company. So in some sense, this is progress, and prohibiting the development of services will only lead us into a blind alley. But I think that some governments do not pay enough attention to the relationship between the base operators and those operators who work on the basic infrastructure, who offer over-the-top services. And so if one company aggregates the data like Amazon or Facebook, and another company gets access to this data and uses that data to promote their goods and services. And so this collision, this is a collision. You cannot prohibit progress because WhatsApp services are better than the services of the traditional operators, conventionally speaking, but we will be facing this situation in the next 10 years, and there is no mechanism or tool that will resolve this collision. And maybe some of you have some ideas about how to resolve this issue, because we've been discussing this issue many times and the solution is not found. Prohibiting or establishing national or national limitations is impossible, because commercially speaking, people are interested in using such services, but at the same time, the ownership right, property rights of ones is infringed upon by the property rights of others. And it would be my pleasure to talk to you about this.
Comments. There is the issue of appropriability, which I think is key in this context. Of course, these firms are investing a lot of money the same way, that intellectual property rights holders sometimes are investing on research and development in order to develop basically new products that are patented or protected by intellectual property. However, we have set limits to their right somehow to appropriability in this context. And the question is, what is the right limit? I mean, one might say that you might develop a reward theory. So you have basically to be rewarded for the expenses you have incurred, but no more than the expenses you have incurred. And I include there the risk as well that there is a failure. That will set a limit, let's say an upper limit. I mean, you might have a different approach, which is an incentives approach, in the sense that we have to provide like a huge prize, some form of a lottery, basically, where that will enhance the incentives of people to invest in this type of, grand data collection, or in the case of intellectual property, could be like more research and development. But these are very unsettled questions in terms of, what theory you adopt. I mean, in terms of reward, incentives, or you might even adopt a theory which is that, well, let's provide a property right to everyone. And then let's leave the market and transaction somehow take the issue forward. And that could be possibly, if you think about the privacy regulation as enabling, empowering an individual to acquire part of the value of its own somehow personal data. So I will say, like, privacy actually creates property right of the individual on its own personal data, in the way that data will be used, because it's not prohibited that you collect the data. It's what is prohibited is that you use and make compatible uses of that data. So in a way you bring in consent, then one might say that this is very close to, in the intellectual property field, or the property rights approach to somehow transaction actually approach, in the sense of let's provide basically intellectual property rights to everyone, or at least let's provide to everyone that proves some form of investment with very, very lax criteria, because the market actually will develop, and these people will license each other, and these people will somehow, through transactions, will develop the products, and the property rights are there in order to develop the market. So a new market will develop because new property rights will develop in that context. So in a way, I mean, we are not necessarily fixing intellectual property. I would guess even here is even more difficult to get there. So I might probably stop here. And yes, of course, yeah.
Well, this possibility, or the right to provide agreement to use the data or to prohibit the use does not create any property. If you don't forbid, you've lost, and there is no input. There is no investment. You can say, this information must not leave this room or this website. I prohibit to study my data. I will get an answer to the question I asked. My interviewer will also get the answer, but this data will be between us, will not be given to third. This will be the privacy right, but that does not mean that when I agreed that my data be used, I made a contribution to the big data, to the aggregated data. There is no contribution. And then these things are easy to collect. I can look at people and I see whose eyes are blue and whose eyes are black. And I have a computer in my head. And I need that data for some reason. I haven't robbed anyone. There is no problem here. It's like picking mushrooms in a forest. And then this becomes my information. And if there is demand for this information, I will sell it. Why not? I created that information. It did not exist before I asked that question. And my computer in my head solved that problem. I knew there was demand. I knew where to get that information from. I have absolute memory. So I will remember this information. But there is no... But you didn't contribute to the creation of that information. This is an object of observation. And privacy does not create any property effect.
Well, if you think about it, I mean, let's take for example, a quite classic case in European competition law, the IMS NDC health case, which concerns basically some form of brick structure for databases with regards to pharmaceutical sales in Germany. And you had one company that somehow relying on the information provided by somehow consumers basically behaving in the market and observing that, they created this brick structure which apparently was extremely successful and became an industry standard. And you have one of their competitors that had tried somehow to do something equivalent, but their structure actually they wasn't that successful, and they had demanded access to this information and to this basically brick structure from that particular company. And if you think about it, you might have a cumulative innovation issue. You might, why should you provide the first comer somehow the right basically to foreclose the market to any other competitor, leading somehow to losses of consumer welfare because they were the first to. I mean, of course, it's a reward theory, but then the question is, should we somehow provide like full like more than just a reward of the investment because they were the first to observe or to ask the right question or to make that particular observation if there is a social welfare, let's say, a reason to enable someone else to have access to that information and provide, let's say, a product or a service that might correspond to some of the consumer preferences. So in a way, or it's probably the fact that we want to have more than one monopolist basically in that particular market because we consider that competition and rivalry will provide some social welfare benefits, or it could be issues with regards to the centralization of economic power. I mean, if you think about it, I mean, why should we provide to one company the possibility to control all these important assets and values, and not necessarily, that might create problems for democracy, for a number of other, let's say, no, I mean, you don't take a welfare perspective, more deontological, let's say, view about, protecting democracy, protecting economic democracy. So, in a way, I think, you need to bring some form of balancing, basically, mechanism. You cannot only rely on categorization, oh, this is a property right, and let's actually have a question about the boundary of that particular property. I mean, you need to bring basically this idea of balancing of interests into account, and areas like antitrust or definitely rely on this particular balancing approach to obviously protect the investment, let's say, of the of the firm that was a first mover, but at the same time making sure that other interests like consumer interests are taken into account.
I agree, by all means. The property approach will be unilateral. Thank you very much, dear colleagues, for the interesting discussion. And Our time is up. I think the discussion was really quite deep and interesting, and the colleagues approach the problem from different viewpoints, and unfortunately there are no distinct answers to the questions. There are no clear boundaries of private life. There's no clear understanding of what is welfare for the users, for the people, and how on the one hand to protect the investments and on the other hand to maintain competition, on the third aspect to levy taxes in the country where the money was paid, and fourthly to ensure their national security. But luckily or unluckily, that is a legal reality which we have to comply with in near future, and I think that will be really great and interesting. I would like to thank all the participants.